Can a PTO or informal land right become full ownership or be upgraded to a title deed? This has been the burning question in the last video that I posted, and the short answer is yes, but let me explain. We have the ULTRA legislation that deals with upgrades, and ULTRA stands for the Upgrading Land Tenure Rights Act. Its main job is to convert old apartheid-era trading or occupation rights into full formal ownership, and this applies to things like PTOs, permission to occupy, RTOs, which is the rights to occupy, old leaseholds or deeds of grant. And the case in point is, look at the famous Constitutional Court case of Rahube versus Rahube. This case is a perfect example proving that if you have been a long-term dweller on a piece of land, these upgrades can and do happen. Okay, but what if you can't upgrade to full ownership? Can you just be kicked off? Not easily. That's where IPILRA comes in, the Interim Protection of Informal Land Rights Act. IPILRA is a shield. It protects people living informally on communal or rural land, and it states that you cannot be deprived of your informal land rights arbitrarily or without strict legal process. We saw this in the Maledu case. The Constitutional Court stopped a mining company from removing community members because they hadn't properly complied with the IPILRA protections. Another interesting case was the Council for the Advancement of South African Constitution and others versus Ingonyama Trust, a huge landmark case where the courts protected the PTOs and RTOs of dwellers from effectively being changed into leases where they are renting the land. The court found that the lease conversion program was unconstitutional. Why applications can fail? Let's talk about that. Even when applicants meet the requirements, the processes can fail due to significant administrative and institutional challenges. So applications may be rejected if the land has not been formally surveyed or recorded in official land registers, and the traditional council has not initiated or supported the process to formalize or upgrade the land tenure. Also, formal agreements or coordination mechanisms between municipalities, relevant government, and traditional councils are absent or incomplete. Without those technical processes, legal frameworks, and institutional coordination in place, the upgrade of land rights is unlikely to proceed. And here's the part you've been waiting for, how an upgrade actually happens. If you want to move from occupation to ownership under ULTRA, it usually follows these procedural steps. Step one is that you prove the right. You need a physical PTO or RTO document, tribunal authority records, or proof of long-term family allocation. Step two, you need to file the application, submit your ID, property details, and supporting evidence to the department. Step three, public notice and investigation. So notice is given to interested parties. If family members or traditional authorities object, then the government investigates. Step four, deeds office. This is where the registration happens and it's approved formally, and yeah, a deed will then be issued if all those things are done. And yeah, feel free to fill in any gaps where I have not mentioned critical or important information. And remember guys, I'm still in law school. Many of you have been reaching out to try and see if I can do consultations. I'm still a student, keep that in mind. And also please support my YouTube channel, Law with Lwazi. I'm also on there. God bless.